Hello, my name is Mike Tesaro and I've prepared this video presentation entitled Alphabet in the Soup, Google facing three multi-billion euro abuse of dominance fines. Very proud of my pun, Alphabet in the Soup, as well as the image that I found there, which obviously, as you can see, has the word help me in the middle of a bunch of alphabet soup letters. Bit of background about myself. I'm a competition and consumer lawyer and I've been running my own practice to Tesaro Law Consulting for the last 13 years. And I help companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years in a few different roles. One of the roles was as a director of enforcement. So in that role, I gained a pretty good understanding of these type of cases involving misuse of market power and abuse of a dominant position. Now, that on the presentation, I'll start with a little bit of introduction, then talk about three cases: the comparison shopping case, Android case, Adsense case, and then finish with some commentary. Now, the introduction is that I based this presentation on an article which I wrote a few years ago, which was looking at the comparison shopping case decision when it came out, and also outlining a little bit about both the Android and AdSense cases, which had not been finally determined by the EC. So what I've done is updated this presentation to take into consideration developments in relation to these three cases. The comparison shopping case starts with a conclusion by the European Commission that Google was a dominant player in the national markets for general internet search throughout Europe, and that was due to a market share of over 90%. So that's a key finding which resonates through all the three cases. And the conduct of concern was that the EC believed that Google was seeking to advantage its own comparison shopping sites, which is at the time of the case Google Shopping, but had been known by different names previously, by firstly giving its own product benefits in terms of higher placements in general searches, but also demoting its rival competing comparison shopping services by giving them a lower rank than would be justified using the general Google search algorithm. Now, what the EC found was that the actions by Google had had the impact or the effect of reducing the placement of Google's competitors to page 4 of a Google search result, which, as we all know, is a page that a lot of consumers don't go to. If you're on page 1 or 2, you're not going to get seen by consumers. They also found that this demotion of rival sites had been achieved through the use of two specific algorithms which were designed for this purpose and released in 2004, 2011. And these algorithms had the effect of actually reducing the number of clicks on these competing sites by up to 90%. It's also interesting that the way the conduct was rolled out, starting in Germany and the UK in 2008, and then being rolled out effectively across the rest of Europe over the next few years. Now, not only did the competitors' sites get disadvantaged, but the Google products were significantly advantaged with big increases in traffic growth. As you can see there, the traffic growth increase to Google shopping sites increased dramatically. For example, the UK increased 45-fold and Germany 35-fold and so on. So its actions had a significant impact in creating quite a gulf between Google's comparison shopping sites and also its competitors' shopping sites. The EC concluded that this was a strategy that Google had implemented, and it wasn't about attracting customers to its site. It wasn't about making its product better. It was really about using its market dominance in the search engine area to promote its own business and to damage its competitors. And that conduct is illegal under EC antitrust laws. In actual fact, it's illegal under antitrust laws and competition laws anywhere around the world. And what EC found was that Google had denied its competitors the opportunity to compete on the merits and to innovate, and that consumers had also missed out by not getting the most appropriate search results. Now, As a consequence of the finding, the EC imposed a penalty in June 2017 of 2.42 billion euros, I should say, which is a very large penalty, obviously. And that was appealed by Google to the General Court in almost immediately. And then on 10th of November 2021, the General Court issued its decision upholding the EC's decision. The General Court found that the conduct was anti-competitive, that the EC correctly identified the harmful impacts of the conduct. They also dismissed the objective justifications which Google had raised about its conduct, and finally they confirmed the penalty amount. So that was a big win for the EC, having their decision upheld pretty much on all grounds by the General Court. The Android case is also an interesting case, and it does start off with some findings about the dominance of Google in various markets. The first market was obviously the national market for general internet search, where the EC concluded that Google had a dominant position, but the EC also found that Google was dominant in the worldwide market for licensable smart mobile operating systems, excluding China, so looking everywhere else. And the conclusion was reached that they had a market share in that particular market of 95%. The final relevant market was the market for app stores for the Android mobile operating system. And again, the EC found that Google was dominant in that market, excluding China, with a market share of more than 90%. So there's a number of findings being made that Google has a dominant position in a number of different key markets. And the allegation was that EC claimed that Google had used this dominant position to manipulate handset makers and telcos to enter into these exclusive deals in relation to Android and to pre-install various Google apps such as Google Search and Google Play on their devices. Again, the Commission was concerned that Google was aimed at implementing a strategy to stifle choice and innovation in a range of different markets, and again, using its dominant position in internet search to achieve that outcome. The types of conduct specifically identified by the EC involved tying arrangements. So there was tying arrangements in relation to the Google Search app, as well as tying arrangements with Google Chrome and the Play Store. So those were quite prevalent, but also there was licensing agreements which were conditional on anti-fragmentation agreements. So basically hardware manufacturers were not allowed to fragment the position of Google applications on their devices. So they weren't permitted to sell devices based on modified versions of Android, so that was called Android forks. They weren't able to take actions to cause any significant fragmentation of the Android operating system. And also there were some restrictions associated with the distribution of software development kit derived from Android, which is a range of applications that are available for Android operating systems. It was also found that Google was entering into these revenue share agreements with original equipment manufacturers and network operators to effectively pay them to pre-install Google applications and programs and not to pre-install competing products on any of these devices. So there was a very interesting diagram that appeared in the decision, which was based on an internal document within Google, which described the strategy in relation to Android as the carrot and stick strategy. And effectively, Google internally is very clear on the fact that if these different third parties are willing to work with Google to exclude competing products, that they will get significant advantages. They'll get carrots. But those who do not seek to or do not agree to these agreements or do not consent to working with Google to maintain the position of Google on their devices will suffer the consequences. They'll, I guess, get the stick. So there was quite clear evidence, I think, here that there was this broader strategy to seek to expand the dominance of Google in a number of different markets. And Commissioner Vestager commented on the case and noted that Google had engaged in three types of main restrictions to prevent Android device manufacturers and network operators from supporting non-Google products. And again, the identification of Google using Android as a vehicle to cement the dominance of its search engine. So it's all about protecting the search engine from competition. And as was the case with the comparison shopping case, a concern that the conduct had denied competitors the opportunities to innovate, compete on the merits, and also the conduct had denied consumers the benefits of effective competition. So there was a restriction on the level of competition in the market. So on 18th July 2018, the EC issued a fine against Google for this particular conduct of 4.34 billion euros, which is an enormous fine. And the size of the fine, reflects just how serious this conduct was and the fact that it had negative anti-competitive consequences in a range of different key markets. There were also other remedies that were part of the EC decision which were aimed at preventing the continuation of infringing conduct. So there were effectively injunctions on the continuation of various tying arrangements and license agreements. And in September 2021, Google appealed this particular case to the General Court, and no decision has been handed down yet. The last case involved Adsense, which is the same thing as the ad tech industry in Australia, and effectively it is the vehicle by which Google promotes advertisements for itself and for third parties. And the EC in this particular investigation identified three separate infringements. The first was requiring publishers to source all or most of their search advertising from Google, so a requirements obligation. Also, there was an obligation to reserve the most prominent space on search result pages for a minimum number of search ads from Google. So effectively it's saying to the publishers, you have to reserve a certain prominent space on your search result pages for our ads, and there has to be a minimum number on those pages. So two specific restrictions there. Finally, there was a requirement for publishers to seek approval from Google before making changes to the display of competing search ads. So one specific conduct that the EC found was the introduction of what was called the premium placement clauses. And under these particular clauses, publishers were required to reserve the most profitable space on their search result pages for Google advertisements. And also, there had to be a minimum number of Google ads on these particular pages. So as you can see, that's a way of using the power which Google has in those markets to advantage its own advertising business. Commissioner Vestager commented on this particular case, and she noted that it was again an attempt by Google to cement its dominance in the online search advertisement market and shielded it from competitive pressures by imposing these anti-competitive contractual restrictions. So it's a different market. It's not so much related to the general search. It's rather trying to preserve its dominant position in relation to the provision of these online search ads or the ad tech market. And again, this conduct is illegal under EU antitrust rules. Notably, the conduct lasted for 10 years and denied a lot of companies the ability to compete on the merits and to innovate. And again, there was seen to be a detriment towards consumers. And the EC decided in March 2019 to impose a fine on Google of 1.49 billion euros in relation to this conduct. And in June 2019, Google appealed this case to the General Court. But just some commentary here. This particular conduct that the EC has uncovered is conduct which would be considered to be anti-competitive and illegal in most jurisdictions around the world, including Australia, using your market power or dominant position to self-preference yourself, to damage your competitors, to restrict the level of competition would be illegal in Australia, particularly given that Google's market power in these particular markets is very high as well. It has a very strong position in general search, in ad tech, and in a number of related markets. So the question is whether this conduct is occurring in Australia, and if so, when the ACCC is going to commence legal proceedings against Google for Australian detriment. The other interesting thing here is that there's a number of other cases around the world which have been taken in relation to Google, which are identifying other particular concerns. So, for example, there is a case that has been taken by the Competition Market Authority in the UK, which relates to Google's privacy sandbox, which is aimed at removing third-party cookies from Chrome. And the concern which the CMA has is whether Google is seeking to monopolize data gathering by the use of its privacy sandbox. There's also the private litigation that we have heard about involving the developers of the Fortnite game, namely Epic Games, which has commenced legal proceedings in a number of jurisdictions, including the UK, Australia, the US, alleging that both Google and Apple have misused their market power or dominant position in markets to kick off the Fortnite game and allow the use of other payment methods on these particular Google and Apple sites. There's also some other cases around the world in relation to Google. A number of private actions have been commenced. In the UK, there has been private actions commenced in relation to the Android case, and that's proceeding over there. And in June 2021, the EC launched a further investigation into Google abusing, allegedly, its dominance in relation to the provision of intermediation services between advertisers and publishers. That's a second case in that advertising area that's separate to the Adsense case. So the next steps are going to be interesting. Like, as you may have heard, a lot of different jurisdictions are bringing in laws to try and deal with the question of the dominance of a lot of these large digital platforms. And the Australian Competition and Consumer Commission has issued a paper seeking to canvass ideas. But I think the main issue has to be, how can we have a enforcement system that can operate in a quick manner to deal with the rapidly changing competitive dynamics in digital platform markets. I think the current systems are very slow, can be dragged out for a long time in court. I think we've seen the EC cases taking between 8 to 10 years to go from commencement to completion, and that's really too long in these very dynamic markets. The other issue that's very relevant is in the period that the matters are being investigated competitors are going to be driven out of the markets, consumers are going to miss out on the best services. So you need quicker remedies, and that's why the ACCC is looking at a wide range of remedies, codes of conduct, potential rulemaking powers, and other remedies to, I guess, be able to address anti-competitive issues arising in digital platforms in a timely manner. So it's going to be very interesting to see how things pan out. But I think we'd all agree that the conduct which the EC has identified in relation to Google in the European context is very concerning. It's conduct that clearly would be illegal in, as I said earlier, every other jurisdiction around the world. And there's little doubt that this conduct has been engaged in other jurisdictions. So there's a real issue here. I think a lot of commentators are suggesting there's nothing untoward occurring. Well, the evidence seems to be contrary to that, that there is anti-competitive conduct occurring and it's having a detrimental effect. It's really important that we try to work out some mechanisms to deal with it. That's all I had. Hopefully that's been helpful to just give an overview of these three important cases. And if you have any questions about this presentation, please feel free to give me a call or drop me an email. Bye-bye.